This is about Robert Walker Jr.'s hearing, but I gotta show you this first because I heard that he was held for 7 days before he saw a magistrate. Well, here is one of the excuses they used for doing that, which is absolute garbage. And this old squishy gardener is covering for them by omitting the truth, which is actually on her channel. Basically, they say you refuse to give pictures and prints.
Your Honor, can I please go home? Your Honor, can I please go home? I'll leave.
All right, well.
Can I go home?
I left it up to them and I left it up to you, and then they were to behave accordingly.
And you get a speeding
No, we're not
ticket.
gonna do that, sir. I just need.
All I want to know is the fine. Like normally when you get a ticket or a citation, somebody give you.
I told you that. I've told you that.
When you held me in contempt, they went out and searched my car, which was a violation of my Fourth Amendment right.
Look how excited she is about violating this dude's rights. That is so fucking disgusting.
In a crime investigation or any kind of criminal intent or doing anything, so my car was searched.
Well, I think you, as I understand it, you were put on lockdown because you wouldn't go through booking and processing. They couldn't get you entered into their system.
No,
You refused to get your fingerprints and you refused to get your photograph, and rather than manhandle you and wrestle you and get you to take your pictures and prints, they had to just put you somewhere safe until you would cooperate. But
that wasn't
what I've heard. I don't know that for a fact.
Well, if you look at the video, that is inaccurate. When I came in, I was told I was going to be.
Okay, sir. We'll talk about that just a little bit. Okay. Prints taken. I'm going to order the.
So that's what the old squishy channel is trying to cover for. But here's here's what really happened. Here's the hearing where she admits that she had to first release him before anything.
Then we're going to have to do more.
I ain't got if you saying I could leave, fingerprint, and that's what I asked them last week. Would I be able to leave if I give y'all fingerprints and photos? They told me no.
Because you've got that military hold.
And I was fine with that, but I was asking about that, Your Honor. I'm not trying to drag this along, but I asked them about that. Is the military going to be allowed to come pick me up? And they told me, no, I won't be able to leave until I come before you. So
I wait to take care of your charges here before you go. That's
okay.
All right.
I will.
I just felt like offering that up because it seems to me like that's what they're going to try to say, because that's the only reason for holding this guy for 7 days without seeing a magistrate is because he refused to get his pictures and prints. But we all know that's bullshit because they pulled that shit before right here to prove it. Anyway, okay, these are the body cams that were provided after the hearing. Anyways, just watch the timestamp whenever the lights turn on.
You for disorderly.
Where the fuck disorderly?
12/31/50. 12/31/50.
And whatever else you can fucking think of.
So right there. I'm just saying. Sir? Sit down. Sir?
You
Sit down.
don't push me.
You don't freaking kick my chair.
I kicked that fucking chair. I paid for that fucking chair with my taxes, you dumb bitch.
Sit down.
Oh, shit.
Sit down.
You can fuck off.
And then here's their evidence from that first evidentiary hearing in whatever, November or whatever it was, August, I don't know.
Whatever the fuck disorderly?
Lights come on at 12/31/44, not 12/31/50. That's weird.
And whatever else you can fucking think of.
Sit right there. I'm just saying. Sir?
She's already in mid-push by 12/31/50. Wonder why that is.
Chair with my taxes, you dumb bitch. You dumb shit.
Sit down.
You can fuck off.
Pretty good audio for a closed circuit camera that's like really far away, but not the point. So this was on November 13th, 2023, and the title of this video on the Old Squishy Gardeners channel is Resisting Arrest or Major Felony, You Decide. Now remember, this is in November, November of 2023, right? Fast forward now to October 30th of 2024, and now we have this debate
of what appears to be a third amended complaint and information, though it is not labeled as such. I have it printed out. I don't know if I understand totally what the implications are of the amendments, but we will proceed further at this time. Regarding the first motion that the court is going to take up this morning, and that is the motion to dismiss or amend. Mr. Pate, if you just summarize for the record here, what are you seeking by this motion?
Well, Your Honor, the third amended complaint filed this morning at 9:31 resolves my motion to dismiss. The request was that count 3 be properly amended back to a misdemeanor battery on law enforcement. This amended complaint accomplishes that, so this motion is moved.
Well, Mr. Pate, I do not totally agree. Count 3, and the state has had multiple opportunities to clarify this point. Count 3, in the view of the court, does not properly charge battery on a law enforcement officer. It charges battery. There's no allegation in the text of count 3 that identifies that this was a battery on a law enforcement officer. It uses the name of Deputy Annie Bliss, but the reality is the law enforcement officer is an element of this offense. That element is not charged in this particular document. And quite frankly, the amendment, if any, should be to a Class B battery, just based on the language of the charge. Do you disagree with that, Mr. Pate?
Well, Your Honor, actually, I think that is a proper analysis, and the focus of my motion was inexplicably between the first amended and the second amended complaint information. It was elevated from a misdemeanor battery law enforcement to a felony battery law enforcement, and that was the focus of the motion. But I do agree, upon further review, the court is correct. It does not have the additional element of law enforcement in the actual text of the complaint. It has it in the title of the charge, but not in the text.
It's so weird how all that just fell into place right there. How the amended complaint that she, for the third time amended in the morning of, renders his motion moot, but then the judge says, oh, no, it doesn't. And then explains why, because of the law enforcement issue. And then they continue on. This is orchestrated, because the only way that, oh my God. Okay, before we get into all that, let's start with the easy stuff.
You don't need anything?
Do I need you come up here asking me if I do? Did I stop you?
No, I'm approaching you.
Okay, so notice how his voice and the audio match up perfectly. And this is supposed to be supposedly the exact same footage later on. Like, this is all supposed to be one long video clip, like she never turned her thing off.
Right here.
You're being disorderly. You're being disorderly.
Know what disorderly is?
Yes, you're causing a problem, and you're expecting me. You're cussing at me.
You can't be the complainant either, can you, moron?
He's right. She cannot be the complainant or the victim of a disorderly conduct charge, and there's nobody else around right now when he gets arrested to say anything. There should be no trial just by this footage alone, because anything that happens after it is just fruit from the poisonous tree. We all know that, but let's see how they try to twist it.
Excuse you, sir?
I just said you was a fucking moron.
Excuse you, sir.
I said it again.
All right, you know what? I will arrest you. You know what? All right, you are under arrest for disorderly conduct.
Right?
No, I need you to turn around and place your hands behind.
Now, same exact body cam clip, just further along in the timestamp.
It again.
Are you a regular user of drugs and alcohol? Okay. You ever tried to commit suicide or do serious harm to yourself? Any current health problems or issues?
Did you get his charges?
No, I haven't put him in yet. I was just moving on. I didn't know what we were doing.
Well, there's probably a few things that we're gonna do. Let's go back to that.
Pay attention to when she starts typing and when you can actually hear the type.
Get his charges?
No, I haven't put him in yet. I was just moving on. I didn't know what we were doing.
Well, there's probably a few things that we're gonna do. Let's go.
Thank you, Summer.
Did you hear how off that audio was whenever she put down the glass of water or whatever? And he says, "Thank you, Summer," who is the one that wrote the statement, I'm assuming, because it said Summer on it. That's the only time that she even saw him, it looks like.
Thank you, Summer.
Well, here's a document called Recommendations for Video Conferencing in Kansas Courts. All right. Go down to D. Audio and visual recordings must be synchronized and undistorted. Fail. Epic fail. Now, let's start with the very first words in this trial.
23 CR 30 and 33. Right. Before the first witness, is there any preliminary matters that we need to address?
I don't believe so. I have two witnesses here, so I didn't know if Mr. House was going to sequester them or not.
Mr. House?
Well, I think it'd be a good idea to sequester them, yes.
Very well. I will grant the defense request for sequestration. Ms. Gillette, who will your first witness be?
Mr. Watts, Your Honor.
All right. Ms. Bliss, if you could go back to the waiting room. Don't discuss your testimony with anybody until you're called as a witness here, please.
Yes, Your Honor.
Thank you.
What the hell? How is she supposed to bring herself back to the waiting room unless she is a co-host or a host? She can't. Noticed how he said, "Miss Bliss, can you just go back to the waiting room?" She can't do that without somebody putting her there. Unless she is a host. Well, there is one other way. If there's another device open that she's on, which there is, because out of those four squares, take a look.
Versus Robert Walker Jr. Case number 23 CR 30 and 33. Right. Before the first witness, is there any preliminary matters that we need to address?
I don't believe.
Remember, that green square follows the audio of who's currently talking, right? So wait till you hear her.
I have two witnesses here, so I didn't know if Mr. House was going to sequester them or not.
Mr. House?
Well, I think it'd be a good idea to sequester them, yes.
Very well. I will grant the defense request for sequestration. Ms. Gillette, who will your first witness be?
Mr. Watts, Your Honor.
All right. Ms. Bliss, if you could go back to the waiting room. Don't discuss your testimony with anybody until you're called as a witness here, please.
Yes, Your Honor.
Thank you.
Well, she's been there this whole time. And guess what? That square never leaves. So all she has to do is just hit mute, and that green square will never go back to that white square to let us know that she's saying they're doing anything. She can hear it. She can hear all of this. It's ridiculous.
30 and 33. Right. Before the first witness, is there any preliminary matters that we need to address?
I don't believe so. I have two witnesses here, so I didn't know if Mr. House was going to sequester them or not.
Mr. House?
Well, I think it'd be a good idea to sequester them, yes.
Very well. I will grant the defense request for sequestration. Ms. Gillette, who will your first witness be?
Mr. Watts, Your Honor.
All right. Ms. Bliss, if you could go back to the waiting room. Don't discuss your testimony with anybody until you're called as a witness here, please.
Yes, Your Honor.
Thank you. And
you might be saying to yourself, "Oh man, it says Sarah, District Court." You can change that. as a host, you can change it to say anything you want. Whoever's designated the host can change that to say anything they want. Now, she changed it to say Sarah. Sometimes she doesn't,
Walker,
because
right
in this
hand,
one,
please.
Arrested. And so any
oh look, she didn't even bother. It just says Jill Gillette, County Attorney, Jill Gillette, County Attorney, twice on 2 different squares in the same hearing, in the very same room, whatever room they're in. Seems like some cheating. Don't believe me? I changed my name to Gilbert on this one. Now, what about the second hearing in between the first and second amended complaints and the third amended, re-amended complaint, right? Okay, well, here you go. Jill just testifies the whole time as the finder of fact.
Is not Deputy Bliss. The victims are all the offices in the Elk County Courthouse that expressed concern over the defendant's behavior and did not want the courthouse doors opened.
So the victims of his disorderly conduct were victims months after the conduct? Give me a break. That is ridiculous. If that's true, then how could you call Deputy Bliss as a witness to any of this? You can't, because she didn't witness all of the recordings of all of the whatevers.
In their offices, sticking phones in their faces and asking them questions, calling them Nazis.
There's got to be some kind of rule or some kind of thing to describe what she's doing right here. It's like biasing the judge or biasing the jury or biasing everybody. And I feel like the judge should not allow this or something. Like, he should stop it when he sees it, you know?
Nazi baby killers, the B word, the C word.
What does that have to do with his disorderly conduct on that day in front of that cop? I mean, really, who's the real victim with the B word and the C word? Who is she really saying is the victim right here?
Flaunting your laws, huh? Don't pull the door on me, you dumb bitch. Don't pull the door on me. You called me a criminal, you dumb bitch. I'll call you whatever I want.
Is that what she meant by C word, criminal? Or did she mean cunt?
Discretion to do that. It is not onerous to ask Mr. Myers not to call court staff when not public officials.
Take away my rights is onerous.
A cunt. Number 3.
You're a cunt, bro. Your wife's a cunt.
Your Honor, I'd ask Mr. Myers to be held in contempt.
I'll pay the fine. You're a cunt. Your wife's a cunt. How much is the fine? Whoop.
What you just heard there was a guy saying that in court to a prosecutor and about a prosecutor's wife and to a judge, and he was not held in contempt and he walked out of that courtroom.
Repeatedly calling their offices over and over again till we have to hang up on them 4 and 5 times. Even one of the deputy court clerks heard how extreme he was, and calling their office repeatedly would not be appropriate. These personas are working on his behalf and in his contact. They are intimidating the witnesses, in which I am.
The witnesses or the victims? You can't have it both ways. If they're intimidating the witnesses, then that means they're intimidating the ones you've called as witnesses, like the cops. If they're the victims, then they're intimidating the victims, but they can't be victims, right? So she's saying, as a statement of fact, that is third-party contact on his behalf.
Looking at charges for intimidation of a witness 4, that is third-party contact on his behalf. At this time, it needs to stop.
Court will certainly issue an order precluding Mr. Walker or any member of
What a bunch of irrelevant references she's using, jeez.
his immediate family from soliciting case reach a conclusion and be over with. But in light of the late or certainly belated turnover of the medical records, which I think reach a critical issue in this case by the state, and failing to provide that.
Do y'all see how sticking that pen in his ear?
Discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
That's weird. Why would the judge and the cop both make that same exact motion with their finger inside their ear at the exact same time? Weird. Super slow-mo?
at the attorney, at the Butler attorney.
Even more odd, in both cases, they were talking about discovery that wasn't given
to the defense in a timely fashion. I think it's patently unrealistic to expect that the defense can be prepared.
And also this little finger mustache.
For trial by next Tuesday.
Motion to dismiss, Your Honor. You just said it right now. She didn't turn over discovery in enough time. It's been however many days, and 180 days is ticking. So all the shit she just said is all bias on the record. And now, so she's tried everything possible to vacate the trial already. Now he's going to set a trial date, and then guess what? They're going to vacate it again because they're going to switch lawyers. Well, guess who else got recused? Yes, pointy finger in the ear House got recused, and from the one I just showed you where the two were pointing in their ears, Chris Pate was recused from that one.
Motion filed August 25, 23. That was a motion filed by Attorney Chris J. Pate. Mr. Pate filed a motion to withdraw due to the defendant wanting to proceed pro se. And that was authorized based on the previously referred to 7-page document. It would indicate at the time to the court that Mr. Robinson did want to proceed pro se. So Mr. Pate, attorney, was allowed to withdraw. And so here we are. Now, Mr. Robinson, normally
overwhelming urge to itch my left cheek.
I would
of the charging document. And again, the state has had numerous opportunities to either enhance or clarify the language of their various charging documents. The court will have this case go to trial on what's actually being charged.
Oh my God, I have this urge to make a finger mustache.
And again, it'll be the court's ruling that count 3 will go to the jury as Class B misdemeanor battery.
Let's all be reminded of what that was.
Lawsuit against your goddamn
Don't
ass.
push me.
I didn't push you
yes,
shit.
You did. You elbowed me with your
Oh, yeah.
That was it. Did you miss it? That was what she was talking about.
There's your fucking go-to. Is that what you're going to arrest me? Police brutality?
I've already arrested you for disorderly.
Whatever the fuck, disorderly, and whatever else you can fucking think of.
So
weird how he calls it and then she pushes him.
Saying, sir, sit down. Sit down. Sir,
you
sit down.
Don't push me.
You don't freaking kick my chair.
I kicked that fucking chair. I paid for that fucking chair with my taxes, you dumb bitch.
All right. Regarding your other motion to dismiss, Mr. Pate, against the pattern instruction setting forth the elements of an offense of aggravated battery against a law enforcement officer or court official, I will state, and I think in support of the court's continuing position, that number 2 requires that the state prove, and therefore, in the view of the court, originally charged, that an individual was a uniformed or properly identified county law enforcement officer. The charging document does not set forth that language. And that it's not just some reasonable inference that could be drawn by use of the term deputy. I think that the state has to actually charge that this was a uniformed county officer or whatever department the person was with. That wasn't done in this case. Therefore, Mr. Pate's oral motion for essentially amendment and or dismissal of count 4 will be granted by this court, because again, the state has had multiple opportunities to clarify this point and bring that charge within the proper confines of the statute in this case. And the court will grant the motion and show that the count 4 is to be amended simply to a count of aggravated battery.
This is when Deputy Watts come in There's another video clip where
12:33:47.
you can actually see the
So a non-law enforcement officer is allowed to do this to a handcuffed guy with the arresting officer watching.
lights come on as we walk in the video, or walk in the doorway, excuse me.
Well, since you brought it up.
Deputy Watts.
Leave it.
He's being arrested for disorderly conduct.
You can fuck off. Hey, you can fuck off too.
12:33:53 at the exact same time that we just saw was not that. 12:33:53, they're already in the corner. Weird. Listen to the ridiculousness of this. That the dude was in handcuffs, and because he stood up aggressively, that's why the officer attacked him or whatever. But the only reason that this is even in place is because we're under the assumption that Watts is a law enforcement officer. Now that the court just said that he's not a law enforcement officer, how could possibly this man that's in handcuffs batter him as a regular person? The only reason he's there is under the assumption he's law enforcement. No, the only question is how are you going to dismiss this case outright? Dismiss it. How are you going to do it? Or how are you going to vacate the trial again and extend it so you can find a way to argue this one?
Which begs the question, how will that affect severity level, given the current language of the charge that Eric Watts essentially was subjected to an aggravated battery, but not as a law enforcement officer, but merely as an individual.
Well, then you can put the charge on Amy Bliss for allowing a mere individual to attack somebody in handcuffs. What the fuck? Purely going by the record of all the records of this case, the question now becomes clearly, how are you going to vacate the trial and extend it even further without the defense wanting to or having any say in it? It's got to be some kind of life or death situation, right?